We're not interesting. It's only still 10:59. I'll wait till 11. Okay, am I allowed now? Am I allowed?
I set up 10:59.
Still 10:59.
You are authorized as far as I'm concerned.
Use live.
I think so, yeah.
Boom, 11. Okay, we're going to get started. Okay, good morning, everybody. My name is Tina Petito-Kimball. I am Deputy Director, I don't even know what my title is, Deputy Director for U.S. Government Relations for Tata Steel Europe.
She wants to say she's clerk of the Court of International Trade because it comes naturally.
That comes easier, but it's not that anymore. So I am excited to be on this panel today with colleagues who really know what they're doing. I will not tell you how long any of us has been involved in trade law. I noticed that both Richard and Nathaniel were eager to tell you that they've been in this business for over 20 years. I will not reveal how long I have been in this business, but let's just say it's long enough. So with me on the panel today, we have Danny Calhoun, who is Assistant Chief Counsel for Trade Enforcement and Compliance at the Department of Commerce. He advises his agency on litigation matters before U.S. courts, NAFTA, and the WTO. The most important thing as far as I'm concerned about Danny is that before he was there, he was with me at Steptoe & Johnson. We rule. Next to Danny is Bo Jackson. He is a partner at Ducci, Mastriani & Schomburg in Kansas City and Washington, D.C. He splits his body in half, I guess. He has extensive government experience in addition to his experience in private practice. He worked at USTR, and he was a member of the staff on the Ways and Means Committee before attending law school. He was also in the Peace Corps. He was stationed in Cape Verde. His practice includes work in the trade remedies area and in Section 337, which is an area we will be covering today. And finally, Neil Ellis. He is a partner at Sidley Austin. His practice focuses on anti-dumping and countervailing duty law. He has represented a variety of industries and governments. Although his practice focuses mostly on representing importers, he has also represented both importers and the domestic industry. With that, I just want to do the standard disclaimer that applies to all of us, which is that these views are all our own. In addition, it's important here, the topic of this panel is we are going to be looking forward. And a lot of these matters that we will be talking about are still active, either at the agencies or in the courts. And so we're going to have to be a little circumspect, some of us, on how we respond and how we address these issues, because many people on this panel are actually involved in these very interesting topics, right? That's how come we earn a living. So, we might not be as concrete as you would otherwise want us to be on these issues.
So hopefully our opposing counsel hasn't sent spies today or anything.
Well, Heather's up there.
Opposing counsel.
That's true, yeah. That's true.
Nice. So these issues, when you're talking about trade issues and what's happening in trade, for me it's exciting, and that's why I love practicing in this area of the law, because these are issues that are hotly contested. They have political undertones, and it changes. The landscape changes depending on what administration is in place and how they are choosing to use these laws. Right now, I'm sure we all know, the current administration is very aggressive in their use of the trade laws. I work in the steel industry. The steel industry, the 100-pound gorilla in the room is China, right? But it's not just for steel industry. It's for many industries that the trade imbalances and things, it's very much China focused. Unfortunately, what's happening is the good importers, such as Tata Steel Europe, are getting swept into these nets of these remedies are being applied, and they're being applied across the board. And so it's an interesting time because you have this quote bad actor, this entity, the China machine, that everyone knows is where the target lies, and so many other uh, companies are getting swept in. So in this panel now, we're going to discuss that trade landscape and how then the use of the trade laws is being overlaid on that landscape to hopefully, provide a more balanced trade scenario. So Danny is going to talk about what's going on, sort of what the administration is doing right now with that backdrop.
All right, thank you so much, Tina, and it is indeed a pleasure to be here today. I have to admit, I perhaps somewhat naively held out some hope that I would be here in Cleveland during an Indians Nationals World Series, but I guess that wasn't meant to be. Yeah, I know. Well, it hurts for me too, because yeah, that is true. Well, I had actually booked my flight home this afternoon so that I would be able to be at Nationals Park for a Game 3 tonight, were there a Game 3. So be that as it may, we'll go to the topics. First, I'd like to thank Professor Colares and the conference organizers for having me here today and having us here as a panel, and to thank Tina, my fellow panelists. And I would just reiterate the sort of standard disclaimers that Tina just mentioned, specifically the one about sort of active matters. There are probably some things I probably am not in a position to talk about overly specifically, but I'll try to make whatever general comments I can. That being said, I would agree that the theme of this panel, alternative trade remedies, policy, and legal developments, old meets new, really cannot be more timely. Obviously, as Tina just said, the current administration has made trade enforcement a top priority, and I think that's being seen in several manifestations. First, there's sort of the traditional trade remedy tool of the anti-dumping and countervailing duty laws, which is probably, I would say, are probably the primary tool historically that domestic industries have used to get relief. Just for those, I recognize that maybe not everyone here is a practitioner or maybe hasn't had the benefit of taking Professor Claris's class yet. So I would probably just take a quick step back just to make sure everyone knows what we're talking about when we're talking about dumping and countervailing subsidies. And again, these are more general descriptions, not necessarily the legal definition, but the legal definitions are obviously in the statute for those who want to refer to them. But dumping generally refers to when imported goods are sold in the United States at less than fair value. And fair value is usually what the price for the same good, for what the same good is sold for in the home market, or if that price is not available, an appropriate proxy. And countervailing subsidies typically refer to financial contributions from a government that are specific, i.e., they're not broadly available and confer a benefit. And these tools really have their origin going back to the late 19th and early 20th century. So they've been around a long time, and I think that's probably why they sort of are considered the more traditional tools that are at their disposal. And they continue to be used in record numbers, despite some sort of these other alternatives we're going to talk about today. I hate to break it to you, Judge Gordon, but since January 20th of this year through Wednesday of this week, the Department of Commerce has initiated 77 new investigations, which is a 61% increase over the same time period of last year. So the workload is not diminishing, it's only increasing. And in response to sort of the question we had earlier about sort of why is that the case, I think Judge Gordon's response is correct, is that it is countercyclical, and the point that Tina just made is correct as well, that if you look at many of the investigations, or a good number of the investigations that we've initiated over recent years, in the last couple of years, a lot of them relate to steel products, aluminum products, or products that use steel or aluminum as inputs. And of course, these are products that are going through a stage of sort of excess capacity that's caused in part by what's going on in China. And while the countries are sort of having these global steel forums over in Paris on a regular basis to try to resolve this problem, in the meantime, domestic industries have to use the tools that are available to them, and that's primarily the dumping and countervailing duty laws. But that being said, and then as we'll get into later in the presentation, there are a good number of other tools that are now being used in increased frequency. So some of the ones we're talking about are Section 201 investigations, which are safeguards, which are typically before the ITC, Section 232 investigations dealing with national security concerns, particularly in the steel and aluminum sectors, that is currently before the Commerce Department, although a different unit than my client. Section 301 investigations about actionable trade practices involving technology transfers, and of course the 337 investigations that Bo is going to talk about. So I guess one of the questions is that do these sort of increased reliance on new tools speak to the ineffectiveness of traditional trade enforcement tools like the AD/CVD laws? And I think the answer to that is maybe perhaps. I mean, we obviously still are getting a record number of petitions coming in the door and are initiating a record number of cases. But it's important to note that in the case of the 232 investigation, and I know that Neil's going to talk about it in greater detail, I would note that a lot of the orders that we've imposed, we have multiple orders on steel products for multiple countries, but of course that seems to have not addressed some of the concerns, particularly presented in the national security context in terms of the duties that have been imposed on those products. Similarly, in terms of the Section 201 investigations, particularly the one on washing machines, in his remarks this morning, Professor Colares talked about sort of the dumping orders and the CVD orders that have been imposed on washing machines from Korea and Mexico. But I think part of the reason, and I think this is widely known within the trade bar, is that part of the reason that the domestic industry had pursued that safeguards case on washing machines is sort of in recognition that every time they got an order from the Commerce Department, whether it was from on products from Korea or products from Mexico, and eventually products from imports from China, that the primary producers, which are LG and Samsung, would just move their production facilities somewhere where there's not a AD or CVD order in place. And, the anti-dumping and CVD laws are a bit clunky in that, they're expensive cases to bring. They take some time to resolve themselves. Of course, they're subject to judicial review and WTO dispute settlement. So, these tools are not necessarily the most sort of nimble at times. And so, I think that's a large reason why domestic industries and the administration on its own are looking to sort of other options. But to that end, I'm going to focus the next few minutes just talking about some of the increased emphasis or potential reinvigoration of tools that we have available at the Commerce Department in our anti-dumping and CVD proceedings, and then I'll turn it over to the other panelists to talk about some of these other tools as well. So the first thing I'm going to talk about is self-initiation. This is something that some of you who are following the trade press have probably seen a lot about in recent months. Traditionally, Commerce conducts its AD and CVD investigations upon being petitioned by a domestic industry. And usually these petitions have certain sort of threshold requirements they have to satisfy, including making the necessary allegations of dumping or subsidies, but also they have to sort of hit certain industry support standards so that there can be some sort of assurance that the petitions are being brought up on behalf of the domestic industry. However, the statute, as well as the relevant WTO agreements, do contemplate that Commerce can self-initiate anti-dumping and CVD investigations. However, the Commerce Department has only done that on a handful of occasions. I think the total number is 3, and the last one was in the early 1990s. But Secretary of Commerce Ross and others in the administration have publicly stated their desire that Commerce self-initiate more investigations. And that is something that I think we're in the process of looking into and figuring out what might be the best way to do that should we decide to do it. I think the advantages of the desire for increased self-initiations do reflect that certain industries may not be in the best position to actually petition for the relief. As I noted earlier, there are certain petition requirements, particularly with respect to industry support, that sometimes can present problems for a petitioning industry that, in the context of self-initiation, would not necessarily be an impediment. I would also note, just as a practical matter, that it is expensive to bring a trade case. And industries and companies suffering injury who are distressed in some way may not be able to afford that cost. And so self-initiation might alleviate some of that burden. There's also some other considerations. For instance, a U.S. company that has operations or investments in a foreign country and is thinking about bringing a trade case, AD/CVD action against a product from that country, an imported product from that country, might be worried about retaliation, in terms of having sort of business deals quashed or something like that. So in that respect, self-initiation might bring certain advantages and might alleviate some of those burdens. However, I think it's important to emphasize that self-initiation doesn't alleviate all of those burdens. On the commerce side, of course, I think we talked about this morning in the opening remarks from Professor Colares, of course, the AD/CVD is a bifurcated process where Commerce examines whether or not there's subsidies or dumping going on, but the ITC looks into the question about whether domestic industry is injured. Now, before Commerce, once we initiate, typically the burden to provide information falls mostly on the respondent, the foreign companies and governments. But at the ITC, it falls also a large degree on the domestic industry, who has to provide enough information for the ITC to conduct its injury analysis. So it's important that they do be able to participate sufficiently in the ITC proceedings so that the ITC can make the necessary findings if they are going to provide that relief. The next thing I'll talk about briefly will be suspension agreements. Again, under the statute, the Commerce Department may quote unquote settle an AD or CVD investigation by entering into an agreement with foreign exporters or in an AD investigation of a non-market economy country such as China, or a CVD investigation with the foreign government. These agreements suspend the investigation in return for an undertaking by the foreign exporter or government to revise its prices or export volumes. These agreements are generally very rare and do generally require the consent of the U.S. industry before entering into. I think what's of note here is that the Commerce Department in the last year, particularly under the current administration, has certainly signaled an openness to consider these suspension agreements with greater frequency. Earlier this year, the department renegotiated a pre-existing agreement, a suspension agreement involving sugar imports from Mexico. And in a couple of very high-profile ongoing investigations, softwood lumber from Canada, and just this week in the investigation of biodiesel imports from Argentina and Indonesia, Secretary Ross signaled his openness to actually enter into these suspension agreements negotiations and to try to find a negotiated solution. Now, the advantage of the suspension agreements is that they are a negotiated outcome and reflect voluntary commitments by foreign exporters and governments, and are subject to enforcement mechanisms. And they certainly have the advantage of alleviating trade frictions and sort of bilateral relationships. However, I would note that there are numerous substantive and procedural requirements before entering into these agreements, which is partly why why they've traditionally been so rare. The next thing I'll talk about briefly, and I think this will be the last one, the tool is Icer Convention. As we talked about on the last panel, of course, Commerce has a possible role in these in the EPA investigations, but the Commerce Department also does have the ability to investigate what's called circumvention, which is a concept sort of related to evasion. And I think we typically identify 4 types of circumvention: where the merchandise is completed or assembled in the United States, the merchandise is completed or assembled in a third country, minor alterations that remove the merchandise from coverage of an AD/CVD order, and merchandise that is very similar to merchandise covered by an order, but which has been developed subsequent to the initiation of an investigation. Now, this tool has been on the books for some time, and we have used it numerous times in the past at the Commerce Department. Probably a famous example is what we call the pinch of boron cases, where you have a steel order that has a content requirement, a maximum content requirement for boron, and the foreign producer adds just enough to get it over that threshold and then claims it's out of the order. In that sort of situation, we would look at that as a minor alteration or potentially a subsequent developed merchandise, and have found in such cases the merchandise to be subject to a pre-existing order. But what we have seen more recently is that anti-circumvention has sort of been a tool that's also been used at sort of these evasion issues. Currently, the department is investigating with respect to orders of corrosion-resistant steel and cold-rolled steel from China, whether products that are produced and exported from Vietnam that were made with inputs from China should be subject to those pre-existing orders. I think I'll wrap up there. I'll make one general observation. Another tool that's also been used is sort of change circumstances reviews, which has been a tool more to actually exclude companies from orders, but maybe more recently, of course, in one example this year, has been used more for an enforcement purpose. But I think I'll leave it at that, and we'll turn it back over to Tina.
Professor, I just want to congratulate you for your forethought by not putting Neil next to having them in the middle. Actually, was because I know you are ready to jump at the 201 characterization. But before we go there, do either of you have any comments on sort of what Danny characterized as the reinvigoration of those anti-dumping countervailing duty tools? No? Do? Well, you do.
Yeah, so I would just make one high-level observation. Obviously, Danny covered the AD/CVD process and what's going on from the commerce standpoint. But we all have to remember, of course, that there's the ITC side of these cases as well. And I just think it's noteworthy, and Neil can talk about it more if he's able to, because he worked on the case. But there was the first negative preliminary injury vote at the ITC in a long time. I think since 2009. He paid me to set him up like this. In the titanium sponge case, I think it was Japan and Kazakhstan. And so, yes, we are in a time of increased trade enforcement. It's coming directly from the administration. The domestic industries are hungry to bring cases. The petitioner's bar is hungry to bring cases, and all that's well and good. But I think we all have to stop and remember that there are evidentiary requirements that have to be met, including at the ITC, and it's not always a slam dunk that it's going to be injury and therefore duties imposed. So I thought that was noteworthy.
Okay, so now, Neil, we have, the 201 safeguard investigations, and we haven't had one in, 15 years,
Right.
and all of a sudden we have two.
Right.
What's going on?
So just to give a little more background, if I may, on what 201, some of the important aspects of Section 201, so-called safeguard cases. It's important to keep in mind they're unusual because they authorize restraints against imports of fairly traded goods. In other words, there's no sense of unfairness, either no dumping, no subsidies, for example, and there's no necessarily a national security implication either. So the Department of Commerce is not involved. It's exclusively in front of the ITC, and then it goes to the president. What rather is focused on is the impact that the fairly traded goods are having on an industry in the United States. And I should note also, by the way, I am involved in small ways in both of the 201 cases currently pending, so I can't talk a lot about the details of the cases. But the point is to provide a U.S. industry that is being overwhelmed by rapidly increasing imports of a given product into the United States, give it breathing space is the term that's used, to prevent imports or reduce imports for a while, to permit the U.S. industry to restructure and to become globally competitive again. So because you're bringing restraints against fairly traded goods, there is both a higher injury standard and a higher causation standard than is usual in the anti-dumping and the countervailing duty cases. That is, instead of just a cause of material injury, as you may know from anti-dumping and countervail, it's a substantial cause of serious injury. Now, to some extent, you're just playing with adjectives, which I think matters, but nevertheless, there is this clear understanding that both the level of injury and the causal connection to the imports are supposed to be heightened. There's, because you're bringing cases against fairly traded goods, there's an uneasy relationship, if you will, between safeguard cases and the fundamentals of international trade, which since the GATT and then the WTO is based on the idea that fairly traded goods, fair trade in goods is a good thing. Nevertheless, the safeguards are not only permitted by the WTO, but in fact subject to an agreement, so the WTO agreement on safeguards, so there is an understanding that this is a legitimate escape valve, escape clause is what the term is sometimes used, that has been endorsed by the multilateral trading community. Just a couple of items, a couple more items. On substance, the ITC is, and then the president are permitted to impose both import restraints, quotas, or tariffs on these import duties, on these imported goods, or a combination. It is what's called a TRQ, trade-related quota, which is where you have goods are permitted to come in at without quota, without tariff-related quota. That's right. Without tariffs up to a certain level, and then above that level, they then would be subject to tariffs. Now, there's an unusual aspect to this case also in such cases in that the, instead of having the Department of Commerce and ITC, you have 3 inquiries. Two at the ITC, one before the President of the United States, which obviously is quite unusual. So first the ITC looks at whether or not the level of, there is injury of the level that's required. And then it looks at, if so, then it finds what remedy would be appropriate, and it recommends the remedy to the President. Then the case goes to the President, who has 60 days to decide what to do. And his segment of the case is usually handled by the Office of the U.S. Trade Representative with an interagency assistance. The President can adopt the recommended course of action by the ITC, or he or she can do nothing and then explain to Congress why, or the President can take some modification, some remedy, but a modified version of what the ITC has recommended. So you end up having a large, which we're involved in now, a large structure of proceedings in front of the ITC with injury and then remedy, but then the remedy phase kind of falls very intensely into the final 60 days where the President actually makes the final determination. And because this hasn't been done since 2002, as Tina pointed out, there's not a lot of case law, there's not a lot of predictability on what the President phase will look like. There was a flurry of cases in the late 1990s and early O's leading up to the massive case against steel products. But every time that the U.S. government issued restraints under the safeguard cases, one of the unhappy trading partners went to the WTO, challenged the United States, and every time the WTO found that the United States had in fact violated its obligations under the safeguard agreement I mentioned. So as a result, people got kind of tired of it. They said, why bother? You're going to get remedies, and then 2 years later or whatever, they're going to get stricken down by the WTO, and the President would have to withdraw them. So people stopped doing that until this year, when you've got the 2 cases that Tina mentioned. One against solar panels and solar cells, and another one against washing machines. The last point I want to make on this goes to something that Danny said, which is, in washing machines in particular, the petitioning industry, Whirlpool primarily, expressly said that the reason that they were bringing this case was because of so-called country hopping. That is, the Korean producers it was an anti-dumping case against washing machines from Korea, so they moved to China. There's a case against China, and now there's an anti-dumping order on China, and now they've moved to Malaysia and Thailand and Mexico to some extent. But the problem with that conceptually, that sounds reasonable, right? You want to stop this country hopping, anti-dumping cases are expensive and inefficient, you want to stop that. The problem is, remember what I said earlier, is that conceptually you're dealing with something very different. You're not dealing with country hopping of unfairly traded goods. You're dealing with a global problem. Safeguard cases are brought globally, not country by country, against fairly traded goods. And the point is to give breathing space to the U.S. industry, because they can't even deal with fairly traded goods, and they need a couple years to deal with that, to propose methods of reconstructing themselves. So by turning that into a case where you bring against a bunch of countries that are ostensibly engaged in unfair trade, you're kind of muddying the water as to what a safeguard should be doing. And we see where in these cases you are bringing in the flavor, the atmosphere of unfair trade into a case that's really supposed to focus just on fairly traded goods, and you lose those adjectives I talked about, because again, you're saying, well, look, these unfairly traded goods were found in Korea or China, and now they're in Thailand, and you lose the difference between material injury and serious injury, or a cause versus substantial cause. So one, I would submit, without getting into more details, you have to be careful conceptually to make sure that the case is doing what it is, what the law and the agreement were meant to do. Thank you.
Okay, so we just had a very good lesson on 201, and I don't know if, Bo, you have anything to add to that conversation, but I know that in addition to that, if you do, then 201, a tool that is very little used and now being revived. Then we turn to something else the ITC deals with, exclusively no commerce participation, and that is the 337 laws, which have been used, continue to be used, are used all the time, and yet we're talking about them being used in a new way. What are we talking about?
Yeah, that's a great lead-in, and the only thing I'll, excuse me, comment on from what Neil said is it's funny for us trade lawyers how much overlap there is. I mean, I'm sitting here thinking about, Danny mentioned changed circumstances reviews, and now Neil's talking about the solar safeguards case, and I've got a client, and they wouldn't mind me saying this, who's, currently trying to get out of the existing AD/CVDs on solar panels, either through a scope proceeding or through a changed circumstances review with the blessing of the petitioner, only then maybe to turn around and get hit with the new safeguard tariffs from the ITC that are going to be coming. So it's a crazy time where we're all sort of working on various fronts, same types of products, but across various cases before different agencies and courts. So it's fun. So Section 337.
Fun for the lawyers.
It's fun for the lawyers, yeah.
That's right.
Maybe not for the companies.
Definitely not for the company.
Yeah, right. So just by a quick show of hands, who in this room has heard of Section 337? So a little over half, I'd say. I find that to be the case often when I'm speaking at trade panels, and I love the opportunity like this to sort of bring the 337 world back into the trade world, because it's become a little bit more known as an intellectual property litigation world. But as a trade lawyer who practices in the area of Section 337 as well as traditional trade remedy stuff, I like to bring these two groups together. So that's what I'm going to try to do, is put it into the context of everything else we're discussing. So Section 337 is a border enforcement remedy that says it is unlawful to import unfairly traded goods, and the remedy that is imposed by the US ITC if they find a violation of Section 337 is not extra tariffs, it's a complete ban on the importation of those products. So it's an extremely powerful remedy that a lot of people forget about, a lot of US companies don't think about using, because if you win the case, if you show that these are unfairly traded imports, you block those competing products from the US market completely. So that's what we're talking about here. What do you have to do to show that? Basically 3 or 4 core elements: an importation of a product in the US market, or the sale for importation or sale in the US after importation, which means you can name the foreign respondent, the foreign producer, as a respondent. You can name the U.S. importer as a respondent, and you could even name retailers, U.S. companies reselling the goods, as a respondent. So you have an importation. You have to have an unfair act, which in about 90% of the cases is infringement, excuse me, of statutory intellectual property, so a patent, trademark, or a copyright. But there's a lot of cases now that we're seeing that do not involve any intellectual property at all, so that's good to see. And domestic industry. But this is important, especially for the, what I would call traditional trade remedies folks in the room. It's not a U.S. producing industry. You just have to be doing something in the U.S. with respect to the types of products you're trying to protect, to avail yourself of Section 337. So you don't have to be a manufacturer. Statute says if you're making investments in the U.S. economy through R&D, through engineering, through licensing intellectual property, and through traditional things like plant and equipment and production, then you have a U.S. industry for purposes of 337. So it's different than the, quote, domestic industry for AD/CVD cases. And then finally, in cases that don't involve statutory IP, the complainant has to show injury. So that is more like an AD/CVD case. The complainant would have to show that it's been injured or is threatened with substantial injury from the unfairly traded imports. So that's the background on what 337 is. What can you get from it? I already talked about the ban on your competitors' products into the U.S. market. So you get an exclusion order and a cease and desist order, which says the inventory of those products that are in U.S. inventory cannot be sold. So they've already been imported. Yeah, but what if they're already here? Well, you get a cease and desist order that also prevents the domestic sale of those products. But there are public interest factors, and this is another cool twist to 337 that makes it more of a traditional trade statute. So a complainant shows that its IP was infringed or shows that there was an unfair act in the importation of a product, shows it as U.S. industry, and therefore it's entitled to this border enforcement remedy. Yes, although the ITC also has to consider certain statutory public interest factors, namely whether the remedy would adversely impact U.S. consumers, public health and welfare, competitive conditions in the U.S. economy, et cetera. So in most cases, these public interest factors are not a problem. It's very rare for the ITC to completely not issue a remedy because of them, but the ITC is definitely paying increased attention to these public interest factors, in part because of some scrutiny from Congress. Congress in the last couple of years has been holding some hearings and looking into whether the ITC is issuing these broad remedies without thinking through the potential public interest impacts. And I just wanted to note this because it came up on our call the other day, preparing for this, again, talking about you don't have to be a U.S. producer to bring a 337 case. In the last few years, 337 cases have been filed by a company from the British Virgin Islands, which I'll take a little credit for that one, Lego from Denmark, Daimler, Germany-based company, Fujifilm and Canon and Seiko Epson of Japan, Nautilus of Korea, Aker BioMarine of Norway, and a whole host of others. So in contrast to the AD/CVD laws, we do see foreign headquartered companies using Section 337, as long as they're making the requisite investments in the U.S. economy. But I guess that's not so unusual because isn't in the solar case the U.S. producer, but they're a foreign headquartered company, right? So maybe our worlds aren't quite so different. So with that, I'd like to just briefly touch upon a few noteworthy 337 cases that are going on or have happened in the last couple years. And since steel keeps coming up today, I'll start with that one. Many of you have probably heard of the 337 case filed by U.S. Steel. So they already had a bunch of AD/CVDs in place, right? They've been fighting hard on this. But they thought there was some evasion, some circumvention going on. Maybe they weren't happy with the tariffs, didn't think they were sufficient. So I think, somewhat intelligently from a tactical standpoint, they said, let's file a 337 case against the exact same types of products. And specifically, I think it ended up being oil country tubular goods, OCTG products. And they had three specific claims that they said were a 337 violation. Trade secret misappropriation, saying that their foreign competitors, mainly Chinese companies, had stolen their trade secrets and used those to make competitive products. False designation of origin, and this is what dovetails with the AD/CVD orders that were in place, saying they were transshipping the products through third countries to avoid the AD/CVDs. And then finally, some antitrust violations, basically saying that some foreign steel producers were conspiring to fix prices and control output. So some really cool allegations that, again, most people hear 337, they think patent litigation, but this case could not be further from that. Unfortunately for U.S. Steel, it hasn't gone super well. By the way, disclaimer, I'm not involved in the case, but my firm does represent some of the companies as well as a few of the other cases we're talking about. So speaking here only on myself, my personal behalf today. So the antitrust allegation ended up getting ruled upon by the administrative law judge, motion for summary determination, which is the ITC's term for MSA. And they said, yeah, that U.S. Steel had not properly pleaded antitrust injury. That decision is currently pending review by the full commission. So right now, one of the three already is maybe done. Another allegation was pulled by U.S. Steel, the trade secret claim. I'm not sure why, but I guess they didn't have the evidence to meet that showing. And then finally, just a couple weeks ago, the administrative law judge granted a motion for summary determination on the falsely designated claim, saying that there was not sufficient evidence for them to meet their burden to show that the imports of these steel products were being transshipped, et cetera. And U.S. Steel, I don't think, petitioned for commission review of that one. So as it stands, as we sit here today, the case is all but dead, it seems like, unless the commission were to revitalize it with the antitrust aspect of it. So a really cool 337 case that overlaps with a lot of the trade remedy stuff that we're talking about. especially because it was a 337 case brought on products that already had AD/CVD orders in place. Just two other quick ones I'll note, kind of cool 337 cases. There was a bed sheets, U.S. bed sheets company that brought a case saying that bed sheets imported from India were falsely advertising their thread count. You know, they were 300 thread count and they were advertising at 800, which of course makes sheets softer. And most of the respondents in that case didn't show up. So the ITC issued default judgments against them and issued a general exclusion order, basically barring the importation of any bed sheets from India unless the importer can prove that somehow they don't falsely advertise their thread count. So that was a very successful case by that U.S. company to ban the importation of competing bed sheets from India. Again, no connection to intellectual property. That was a false advertising case under the Lanham Act that was remedied by the ITC. And then finally, the last one I'll mention is a case I'm currently working on. It involves Roe v. against Comcast, Technicolor, and Aris concerning set-top boxes. And an interesting issue that's currently on review by the Commission is whether the importation of a cable box, you know, that we all have, that does not infringe at the time of importation. This is a patent case, if you can't tell, but may be used to induce infringement by Comcast customers down the road when they use their remote access app to record certain channels, et cetera. Whether the ITC can properly issue an exclusion order banning the importation of that box, the cable box, even though the box itself is just a staple article of commerce. It is not infringing at the time of importation. So how is the ITC going to rule in that case? It's going to be interesting to see. I expect this will have to go to the Federal Circuit. So there's a case from the patent context that we're seeing some interesting trade implications on as well. So that's my, my quick spiel on how 337 fits into all this other stuff.
So, and that's an interesting, it ties with this morning's panel and, or what Judge Gordon said about the Ford case and how you change things when it comes into the United States. I mean, it's so incestuous. Okay, and so then the last topic that we want to touch on before we open it up for questions has to do with something that I think is rocking the world of all of the trade geeks around, right? And that is that normally trade remedies or, you know, trying to somehow inject the government into the trade sphere is done by a U.S. company making an allegation against another company, right? So Nathaniel's client goes to the government agencies and says, you know, Tina's company is doing bad behavior, right? Which of course would never happen. But that's how the normal path works. Except lately, we have seen the administration itself really jumping in, even more than just the self-initiation that Danny was talking about. We are seeing this administration engage in the mechanics of trade. Shocking, shocking, this administration is engaging in unusual behavior. But we are going to talk about that now. We're going to have Neil talk about the 232 and the 301 investigations. And that's truly not new, but definitely unusual.
Right. So 232. So this is Section 232 of the Trade Expansion Act of 1962. I bet you, if you were honest, nobody in this room ever heard of that. And when these cases were launched, they caused, you know, hundreds of members of the trade bar to scurry off their treatises and look at the last chapter, which is kind of random miscellaneous trade legislation. So it's been invoked 26 times since it was enacted in 1962. Of those, only 5 times were remedies imposed, the last time in 1988. Since the U.S. succeeded to the WTO, this law has been invoked only twice, and both times the president declined to take action. So what's it about? This law authorizes the Department of Commerce to determine whether imports of a product are, quote, in such quantities or under such circumstances, which is vague, as to, quote, threaten to impair the national security. And if so, then the president may take action to, quote, adjust the imports of the product at issue and its derivatives, meaning downstream merchandise, or may take such other actions as the president deems necessary. So this is the Wild West, basically. A couple interesting points since we're short on time. One is obviously the invocation of national security. You know, we're well away from commercial issues. And recall, 62, this was the height of the Cold War. The Berlin Wall had just been built. And Congress felt it was appropriate to give the president authority to deal with imports on, that have national security implications, Cold War implications at the time. Moreover, the concept of security is broadly defined expressly in the statute. It's not just national defense. So we're not talking about imports that might somehow, a flood of imports that might undermine our capacity to build missiles or aircraft carriers, which is the core concept. But also, it means also economic welfare. And again, the statute expressly talks about that. And that could cause, quote, that could lead to, quote, substantial unemployment, loss of investment or specialized skills and productive capacity. So if you take a look like the last two cases I mentioned in the 80s, when these were imposed, they were targeted against imports of oil from Libya and Iran, seen as being national security, having national security implications. Nothing to do with them somehow undermining the U.S. oil industry. Another interesting point about this statute is that in addition to the very minimal description of the substance and the remedies, there's also minimal procedures authorized in the statute. Even Section 201, which I described, and 301, which I'll get to, have very elaborate procedures established and that the agency and the president are required to follow. Here, there's basically nothing. The Department of Commerce has implemented regulations, but they are also quite minimal. It simply tells them they can do whatever they want. The goal is within 270 days, the Department of Commerce has to recommend proceedings to or remedies to the president, and the president then has 90 days to act, and that's about it. One other interesting aspect of this statute is whether or not there is the concept of judicial review even exists. And I suppose it does because of the residual jurisdiction under so-called Section 1581I we heard about earlier today. That is, it clearly is a statute or a remedy that would have an impact on imports. But whether or not, it's never been tested. There's no case law, judicial case law, as far as I'm aware of, under the statute. And whether or not a court, the Court of International Trade or the Court of Appeals or the Supreme Court for that matter, would second guess a decision of the United States President on national security grounds is doubtful. There also theoretically is a possibility of WTO challenge, but because again, the WTO generally says that fairly traded goods are to be permitted. But there is an exception, Article 21 of the GATT, I don't know if you studied this, which does permit governments to impose restrictions necessary for essential security interests. So the question is, would a foreign government bring a challenge against the United States imposing remedies or restrictions under this act, claiming that the United States in fact acted in bad faith and that they were not imposed for the purposes of protecting the U.S. quote, essential security interests? I would be doubtful as to whether a government would do that, or that would be really like the third rail, if you will, of the dispute resolution at the WTO, because it would be very risky for a panel or the appellate body to declare that the United States or any other government for that matter would be acting, was not in fact acting in its essential, to second guess a determination on whether remedies were in the essential national interest. But on the other hand, if the United States were to do this, then the question is whether or not there would not be reciprocal behavior by China or Europe or anybody else saying that, well, we're going to impose restrictions on imports of U.S. soybeans because they're contrary to our essential security interests. So you can get into a real problem with the WTO, I think, if this is pushed to its logical extreme. What's interesting is that the president and Secretary Ross said that they were going to act quickly. I said they're 270 days. When the cases on aluminum and steel were launched in April, they said they were going to decide that the Commerce Department would issue its recommendations by the end of June, and that hasn't happened. Because what you discover is that the United States has a large and complex and interesting economy, and the interests are diverse. So they started having a lot of blowback or pushback or whatever on the idea of imposing significant import restraints on steel and aluminum products, especially when the Department of Defense, which again is the core constituent here, said that has generally said that imports of steel are not significant or troubling for a national defense focus. So now at the moment we are just drifting along. Secretary Ross has now said that, well, he might wrap in any remedies under 232 into the tax reform, which has become the latest focus of government efforts in Washington, and thereby give relief to the steel and aluminum industries through updating tax rules, rather than and kind of let the 232 investigation die. So it'll be very interesting to see what happens here. On 301, am I supposed to go on and talk about that? On 301, I'm getting tired of hearing myself speak. Are you guys getting tired of this? Just quickly again, this is kind of a grab bag. It permits the United States to impose restrictions on imports when the rights of U.S. under a trade agreement are being denied, or an act, policy, or practice of a foreign country violates a trade agreement, or it denies benefits to the United States under a trade agreement, or is unjustifiable and burdens or restricts U.S. commerce. You see, we're getting pretty broad here. Or it is unreasonable and discriminates U.S. commerce. Now, 301 was challenged almost immediately to WTO, and it was found not to violate the WTO by the skin of its teeth, so to speak, because the statutory language was found on its face to breach the United States obligations under the GATT itself, none of these sub-agreements we're talking about. But the panel, the WTO panel, did something unusual. They took a look at the legislative history, the Statement of Administrative Action, it's called, when it reenacted Section 301 in 1994. And there they said, and the United States made commitments before the panel that it did not have to be interpreted in a way that would violate U.S. obligations. And therefore, you couldn't, as a facial matter, say that the statute was always wrong, always in violation, and rather you'd have to look at individual decisions to see whether or not the United States, in a particular case, was violating its WTO obligations. Since that time, it's not been used in the United States. I think one reason could be that if you used it in individual cases to bring restraints on trade from specific countries, you would in fact then be violating the most favored nation aspect of the WTO agreements. So there's been some recognition, I think, that it probably is not the best avenue, because it would end up being stricken down by the WTO at the end of the day anyway. But then this year, just a couple months ago, a case was launched against China and its various intellectual property practices. So it kind of interfaces with other remedies that are being considered and used on IP. And these are allegations in particular that, the Chinese government uses a variety of tools to pressure U.S. companies doing business in China to transfer technology and IP to Chinese companies, pressuring U.S. companies doing business in China not to get the full market value of their licensing fees and for the use of their technology. And also the Chinese government facilitates the acquisition of, allegedly, of high-tech U.S. companies in the United States by Chinese investors, which then would permit a large-scale technology transfer back to China. So, this case is pending. It's in its early stages. The USTR held a public hearing a few weeks ago, and where it was the Chinese interests who showed up and had the bravery to testify were faced with a barrage of hostility and hostile questions. So the USTR now will be deciding what remedies to impose and how to deal with this. I suspect that these sorts of problems will have to require some sort of negotiated agreement between the United States, and the president is going to China, I think, later this year, in order to resolve problems that are this kind of systemic and structural. But it's very interesting. I'll stop there.
So we have 5 minutes. Anybody have any questions? Yeah.
I have kind of a
Oh.
bizarre question. Listening to the Whirlpool stuff, I was wondering whether any of the agencies or tribunals had occasion to address, I guess, consider the valuation of Internet of Things data in dumping cases. That is, where these products are generating, data that has a tangible, quantifiable market value to the importer post-importation and post-liquidation. Does that affect the calculus of whether or not the goods are being sold below cost?
I'll maybe take that one, and Neil can weigh in. Generally not. Generally, a dumping calculation is typically a straight price comparison. So we would look at the price in the home market, compare it to the price, the export price of the United States. And I think some of the sort of criteria or data points that you're talking about really would not be sort of independently considered unless being reflected in the price.
I want to make sure I understand. So you're saying, does data considered that looks at what?
So these washing machines, for example, have operating systems in them. They talk to the internet. They tell Samsung, how often you're washing your clothes, what brand of detergent you're using, all of this data that has marketing value. So hypothetically, part of their position might be, yes, we are selling this at or below manufacturing cost, but we have this recurring stream of revenue associated with this marketing data after the sale that, at least in domestic trade law, I think would be relevant to, whether or not it was a loss leader product and whether it was an appropriate loss leader product. But it's distinct in a way that the ongoing revenue is not a service contract or something, as you might have in some instances. It's not being paid by the consumer.
Yeah, well, as Danny said, the short answer is no. They look at the value of the product, the hardware, as it were, at the time of sale in determining whether or not a dumping margin exists. And Whirlpool or whoever would argue that, they have parallel systems, and the value, the injury to them is being caused by the product that they are not, the opportunity to make a sale that they've had to forego because the price of the imported product was, as a product, was too low. One thing I'd point out, by the way, I have worked in the washer's case, and one thing I gotta say, modern washing machines, for an old guy like me, are really cool.
Yeah, they are. They're
They do stuff that, they're not just a white box in your basement anymore. And LG and Samsung have argued on the injury side of the case that they are the innovators that have fundamentally shaken and reshaped the U.S. appliance industry. But nevertheless, the dumping when you get to the dumping side as opposed to injury, you look at the product that's sold.
I would add one thing on that, is that in the dumping calculation, I don't think what you're talking about would be really relevant, but it could be relevant in the subsidies context to the extent that those type of technologies were the benefit of like R&D subsidies. In that case, as long as those subsidies were determined to be injurious by the ITC, then that's possible that something like that could fit in. But actually, the added value I think that you're talking about really would not factor into at least what the Commerce Department does.
So we are running out of time, and there's one thing that I did learn at Clerk of Court is that if a judge has a question, you let the judge ask the question. And he has a question, so.
Dan, you spoke about the suspension agreement.
I want people in these questions. We can go a little bit.
Can you comment on,
I want to encourage.
you may have left the audience with the impression that your suspension agreement, kind of that ended it, and you and I know that they're subject to judicial.
Oh, absolutely, and I apologize if I left that impression. So suspension agreements are very much subject to judicial review and WTO dispute settlement. There are provisions in the WTO agreements with that. Suspension agreements are basically procedures that are defined in our statute and are subject to judicial review. So in that respect, even though they're negotiated outcomes, there could very well be a party that maybe didn't get exactly what it wanted, and could very well, bring suit at the CIT or potentially even under an NAFTA panel or at the WTO. Additionally, is that these agreements could be subject to renegotiation over time, which I mentioned the one involving sugar from Mexico, where the terms did change to some degree this year after a renegotiation. And again, if you renegotiate, that itself is subject to judicial review.
One thing I want to mention, by the way, if I may, on the washers case, at the introduction, Professor Colares mentioned two cases which our law firms involved by sheer coincidence, Ford and washers. And what's interesting in particular about washers, although this is a topic for an entirely different seminar, is the parallel relation between judicial review and WTO challenges. Because, as the professor noted, the CIT affirmed the finding of both dumping and injury. Well, I guess it was just injury on the washers case, but the governor of Korea then took the washers case to the WTO, and we were involved as a third party representing another government in that case, and the Koreans won at least some of the issues challenging the way that the dumping margins were calculated in the washers investigation. And so the United States is now involved in an implementation proceeding where they theoretically will recalculate the dumping margins. So you've got these really interesting interaction of domestic and international dispute settlement, which I find one of the most interesting aspects of this case, of these whole cases.
So I cut you off, Richard, because I had to let the judge speak. So if you have a question, go for it.
The comment, I just wanted to make one comment, and that may lead into a question, and that is the real-life applicability of what we're talking about probably was demonstrated yesterday when Sears Roebuck cut off Whirlpool after 99 years of selling their products under the Kenmore label for the mere fact that that Korean manufacturers could deliver the washing machines for 10% less than Whirlpool could. So that, the real question is, at least that's what it said in the press. That's what the press said. It was said in the press, how does that play into the various remedies?
Well, again, I can't say too much. I suspect that there's a lot more. If you pull back the curtain, there's a lot more going on in Sears. That's I didn't hear about that. It's an interesting development. The Korean companies say, and this is public because I don't represent them in this case, that they actually price higher. So the dumping concept is really interesting here because what you're doing is you're providing a higher quality product, they say, than Whirlpool and GE. And they also say that Whirlpool has destroyed the Maytag label. But the point is that they're doing a higher price, but not high enough, is the allegation, because the products are so good that, in effect, they're dumping innovation, if you will, that the prices should have been even higher than they are, even though they generally are, if you go to your local store, they are priced higher than GE and Whirlpool. The other point is that I suspect that Sears may rue that decision if import restraints on the Koreans are in fact imposed, because they're going to have to go back to Whirlpool in order to fill their floors of Sears, so they may be back.
The only thing I'll say, I've tried to show restraint because my firm represents Whirlpool, and we keep talking about the washers cases. But Whirlpool might say the reverse of what you said. I think you said Sears cut off Whirlpool. Whirlpool might say they decided not to keep selling those at Sears, for what it's worth.
Very similar
For price
thing happening last week,
complications.
which is the preliminary. The Commerce issued an affirmative preliminary ruling on Bombardier
Oh, yes, right.
C-Series
Yeah.
case,
Yep.
and then you see Airbus getting into is it a merger or a partnership where they are allegedly going to produce, they say in their press release, C-series airplanes, I think in their plane.
In Alabama,
In
yeah.
Alabama.
Yeah.
So there's all kinds of, things are getting a lot faster, and there's different attempts, but the trade statutes are there for the lawyers from the importer or from the petitioners or respondents bar to use, and you've seen a full gamut of all these additional remedies that are in addition to counterfeit eluding CVDs. We are adjourning our conference. We're going to have a 3 o'clock following coffee. We're going to have a 3 o'clock alumni panel where we're going to have some recent case log reads. And Richard is also a log read, but he's not so recent. So we're going to have some recent case log reads, but you're invited to. But you're all invited to come and see this panel with some rising stars that Case has produced and who are actually who are practicing in the trade field. And it would be especially good for students, but everyone is welcome to come back. Thank you very much.